Hi guys, welcome back to my channel. Today in this video I would like to read an article entitled Canada Product Liability Claims in Canadian Maritime Law. Introductions. Canadian maritime law operates within a distinct legal sphere developed and shaped by common law, statute, and the Canadian constitutions. Compared to other areas of Canadian law, maritime law often presents unique challenge to those unfamiliar with its highly specialized nature. Where product liability claims have a maritime aspect or are fully part of a maritime context, legal professionals must have a strong understanding of Canadian maritime law to spot the relevant issues and assess them properly. In this article, the authors provide a high-level overview of Canadian maritime law as it relates to product liability and provide practical insight for commencing or defending this proceeding in Canada. In addition, the author highlight how change in the technological landscape may impact product liability claims in the Canadian maritime context. So what is Canadian maritime law? Canadian maritime law is a single body of federal law that governs maritime and admiralty disputes. It is established in the Federal Courts Act or FCA under which describe the substantive content, which vests jurisdictions over maritime matters within the federal court and the provincial superior courts, generally where it's found to apply to a dispute. Canadian maritime law governs and not provincial laws and or statutes. Historically, Canadian maritime law stems from the English admiralty courts, which exercise jurisdictions over matters or things done at sea. Typically, those have included contract and torts committed at sea, collisions, salvage and rescue operations, acts of mariners, and etc. However, once Canada obtained the right to self-govern under the Statute of Westminster 1931 and the subsequent modern Federal Courts Act, the scope of the Canadian maritime law and jurisdictions expanded beyond what it had been before. Today, Canadian maritime law governs and deals with all claims in respect to maritime and admiralty matters, subject only to the defined scope of the federal government jurisdictions over navigations and shipping matters under S. 91 of the Constitutions Act 1867. Because it is separate body law, its substantive content draws from statutory and non-statutory resources of law, including the common law, national status, international status and agreement, and specialized rules and principles of admiralty. Does Canadian maritime law apply to this claim? The first questions a product liability lawyers must answer is whether Canadian maritime law applies to the claim. Generally, where a claim can be categorized as being so integrally connected with maritime matters, Canadian maritime law will apply. To assess this, the Supreme Court of Canada in INTL Terminal Operators v. Media Electronic developed a three-part test to determine whether a claim falls under the federal court jurisdictions over maritime matters. First, the subject matters of the claim or its pith and substance must concern a matter in respect of which there is a statutory grant of jurisdictions by the federal parliament. This can be satisfied by showing a claim falls under S. 222 of the FCA or other federal legislations that grants jurisdictions to the federal court. The absence of a statutory grant is fatal to a finding of jurisdictions in the federal court. Second, there must be an existing body of federal law that is essential to the dispositions of the claim and which nourishes the statutory grant of jurisdictions as defined in S2 of the FCA. In other words, there must be a body of federal law in common law or statutes that is capable of resolving the issues. Lastly, the law on which the case is based must be a law of Canada as expressed under S 101 of the Constitution Act 1867. That is to say, the claim must fall under a federal head power over shipping and navigations under S 91 of the Constitution Act. However, as will be discussed later in this article, when applied, there are interesting interactions between the second and third parts of the rest, as Madam Justice Wilson foreshadowed in Robert v. Canada. The second element, as I understand it, requires a general body of federal law covering the area of the dispute. No difficulty arises in meeting the third element of the test if the dispute is to be determined on the basis of an existing federal statute. As will be seen, problems can however arise if the law of Canada, which is relied, is not federal legislation but so-called federal common law, or if federal law is not exclusively applicable to the issues in dispute. An example of how maritime jurisdictions may apply to a product liability claim is Bow Valley Husky. Bow Valley was a product liability claim in negligence related to head tracing system installed on an oil rig. The head tracing system was unsuited for its intended use, and after an electrical fault occurred, the oil rig caught on fire. The companies that had contracted for oil rigs sued the contractor responsible for constructing the rig and the manufacturer of the head tracing system in both contract and tort. Among the various issues was whether the plaintiff claim was barred on the basis of contributory negligence. If maritime law applied, any contributory negligence on the plaintiff part would bar recovery to damages. However, if provincial law applied, the plaintiff could claim for damages despite being found contributory negligent. So that's all the article. Bye bye and see you on my next video. Bye.